same way the call's hearing.
Same way, John.
Mathis, you want to call?
Yes, sir.
Ms. Robinette. Welcome back, folks. Thanks for being with us once again today. I do once again apologize for the late start. We have completed our docket and we're ready to resume our trial. If you recall, yesterday we heard the direct testimony from Ms. Morris. It is now time for cross-examination. Who would like to go first?
I'll go, guys.
All right, Ms. Robinette.
Yeah, can you have a moment to set up?
Please. Whenever ready.
Yes, sir. Good morning, Ms. Morris. How are you today? I'm all right. My name is Roy Robinette. I'll be asking you a few questions, okay? Now, yesterday that you testified that Mr. George, the blue Nissan, the infotainment system, the last activity on there for the iPhone 11 was at 3:41:39 p.m. Is that correct?
From the iPhone.
From
That
the
was
iPhone.
not from the Ultima.
Okay, from the iPhone, that was the last activity was 3:41:39.
That was the last scene, yes.
Yes. And this was a connection or a disconnection? What kind of activity was it?
It just says last scene.
Okay. And do you remember, and that was your testimony, correct?
Yes, yes,
Do you remember testifying at the juvenile court hearing
I do.
on November 4th, 2022?
I don't remember the
21.
date, but I remember testifying in juvenile court.
When you testified at the juvenile hearing, you were under oath, correct?
Yes,
And you did testify that you swear to tell the truth,
I did.
the whole truth and nothing but the truth, so help you God. Now, at the transfer hearing, you testified that the last connectivity was at 10:41:39 a.m. Is that correct?
Yes.
So that is different.
I was reading a report from Cellbrite. The Cellbrite report reported 15:31:49 UTC. So at UTC, you subtract 5 in that time zone, when we're in this time zone. That was incorrect. That has since gotten corrected since we did the re-extraction in January.
So your testimony was wrong at the juvenile hearing. Is that correct?
Yes,
And did you prepare for that hearing?
I did, but I did not do the original extraction of the phone
But you reviewed the content of the extraction, didn't you?
at that point, just for that hearing.
But you didn't verify the correctness of the content.
I've read the report that I was handed, which was through Cellbrite, their respected software at the time.
And you were qualified as an expert at that time as well.
Yes,
And the same thing you've been qualified for today.
yes.
Okay, but at that time, your testimony was different than today, correct?
The report was incorrect.
Okay. Now, did you obtain a Burla report for the Nissan?
I did,
Did you review that?
I did,
Will you recognize a copy if I provide it to you?
I'm sure. Yeah, that's it.
What is this document?
That's the full case report that the Burla software produced,
For what vehicle?
the Nissan Altima.
Is this a fair and accurate copy of the report that you received and reviewed?
Yes, but that report is not a supported vehicle, so we were told that we could not base anything on the dates and times or anything extracted from that.
Well, I'm asking you, is this the report that you reviewed? The same report
Yes.
that was provided to you? You know, I'd like to move this into evidence.
witnesses testified to is that she can't be liable.
I'm gonna sustain the objection because it's not a supported vehicle, so it's not reliable.
Yeah, she's an expert testimony. This is from the new Nissan.
But I haven't testified to anything from the Nissan.
But back to the
It's
question.
not a reliable report, so it's excluded.
So when you reviewed the infotainment system in the Burla, there were multiple connectivities in the infotainment system, correct?
For the Fusion,
For the Nissan. I'm only speaking for the Nissan.
I didn't review anything in the Nissan. I just reviewed it and was told by Burla that it was an
I'm not
unsupported
asking.
device.
I'm not asking for about the Burla. I'm asking you. You say that you took a pictures of the infotainment system of the Bluetooth device yesterday, correct?
I took pictures of it, yes, before it was removed.
Okay, and in that, when you took picture of the Bluetooth connectivities, there were multiple.
Yeah, I think there were 6.
There were 6. So, do you know when those devices were connected?
No.
Do you know?
I know when the 2 iPhones were connected.
Okay. Do you know whose the other 4
No.
were? Okay. So when you connect to a Bluetooth, does it show the disconnection date on it?
It only shows the last seen date. That
Okay.
means that that's when that MAC address or Bluetooth address for that phone was last seen on that car.
Okay. So that means that the iPhone or any device can connect just for like 2 seconds, but you don't know when it will be disconnected, right?
I'm assuming I would go with the last seen date is when it was last disconnected.
Okay.
Because
And-
if it stays connected, then the time's going to extend.
Well, I'm asking you, you don't know the disconnection date on the infotainment system. You just testified it's only showed the connection date.
It's shown the last seen date from the phone. I don't know what the
I'm asking-
device said.
I'm asking about the Nissan infotainment system that you took picture of.
Yeah, it just showed that it was connected. The screenshot from the vehicle showed nothing, no dates and times. It just showed the names of the devices that were connected.
Okay, but it showed multiple devices, correct?
Yes.
Okay. And do you have to be in the vehicle in order to connect to the Bluetooth?
Bluetooth usually runs between 30 and 60 feet, depending on the device that's what we're discussing.
So you can be outside of the vehicle when you can
Yes.
if you connect to the Bluetooth, correct?
Yes.
Okay. Judge, can we? I have the projector. I think I'm dim the light. I think we see better. Ms. Morris, this is the report of the cash data that you collected, is that correct?
Yes, some of it, yes.
Some of it, okay. And this was introduced into evidence yesterday, so I want you to review this.
Just wait a minute. Can you get that microphone a little closer to you there? I know, you gotta reach your computer, sorry about
Yes,
that.
sir. I move it this way. Is this better? Now, can you see this?
I've got it here.
So each dot that pops up, does that mean that the phone is being used in some ways?
No,
Okay, so when it pops up, why does it pop up?
it's writing the cache location of that device at that time.
So does that mean that the phone is being used?
No,
Okay, so what is being captured with that by the cache data then?
the phone itself is capturing it.
So it doesn't have to be on to catch it?
It has to be powered on, but you don't have to be using it.
So if I hit the power button to put the screen on, does that capture it?
Does it capture that
The cache
motion
data.
that the screen has come
No,
on?
the cache data. So my phone, if I just hold my phone right here and it's black. Let me demonstrate. Right here. It's not on, sleep mode. Does it capture any data if it's like this?
I don't even know what phone that is.
This is iPhone 14.
I haven't examined it. Some of the iPhone, iOS cache locations is a device specific
Okay, what about the iPhone?
function that it does for customer user ease of use.
What about an iPhone 11 then? If it's in this mode, does it capture anything?
It can, that's when this was captured. When
Okay,
it
so-
doesn't have to be on. You can pull up the screen on and off through a different database. I don't know if it was on at this time, but it does not have to be, it has to be on, it doesn't have to be used.
But you don't know what was captured, is that right?
Not all, everything that was captured.
Okay. So when it captured, is it necessary how long this dot is at that specific location?
No, it just captures it as the location is registered.
So to be clear, you can capture here for 1 second, and the next second the person can be here at this location, is that correct?
Yes, or however many seconds it takes to get there.
Okay. And in here, you have 3 locations. Why are there 3 locations? They can't be in 3 places at once.
The phone's moving.
But if it moves, should that disappear? Or why there are 3 here?
That's just how I geared it for the report, so you can see the movement of the time.
Okay, so it
You'll
once.
have to go by the time. I can't read the time from this screen, what the exact time was, but there's a difference in the timestamp.
Those little red marks have timestamps on them.
Yes.
Okay. So when it appears 3 location, it doesn't mean that the person is there exactly, right?
It's within, that report has got an accuracy with the meters on the other report that was provided. Some of it was as close as like 10 meters, and some of it was as wide as 65 meters.
And when the dot is at that location is captured, it is not necessary that the phone is at that exact point, correct?
It's within however meters of accuracy the report says it is.
Okay. And for this case, you don't know how many, do you know how many points of accuracy?
It's on a different report, yes.
Do you remember?
No, not right offhand.
So, well, then my question is, it's not exact location, right? Correct?
No.
Apologize, John. I think my computer's not responding.
I can turn the screen off there and you can exit out of that and see if you can get back into it.
I'm ready, Your Honor.
Ready?
Not sure how to do it. Ms. Morris, if you can watch the
We
location.
can't hear you.
If you can watch the cache data here. You got 1 second. It's really fast, so this dot right there, do you see that when it appear? Do you see that dot appear?
Yes.
This one. Now, that dot appear at mess that all up. That's dot right there up here at $3:43:57. Is that correct?
That's what it says, yes.
Okay. And this right here is the highway, correct?
That looks like the interstate, yes.
Yes. And this is the exit to go to the highway. Am I right?
Okay.
Is that yes?
I don't know what you're pointing at.
Right here. See?
That's
Okay.
Cherry Street, and that's the exit, I guess, off of 40 West.
Have you been to this
Yeah,
highway before?
I've been to that intersection, I'm sure.
You've been there, but if you get in the highway, there's no exit over here until it's in this location before you can turn around, correct?
I don't understand what you're asking.
All right. My question, when you get in the highway right here, you cannot turn right to be here at this location, correct? When you get on the highway,
That's the on-ramp. The
Yeah.
off-ramp is on the other side of the interstate.
yes, but there's no right turn here, correct?
I don't see one now.
Okay. Now, if you watch carefully with this dot right there, this is at I think my computer died again. The program won't load. This dot right there?
I do.
Okay. That dot timestamp is 3:44:57. 09, correct?
Yes.
Okay. So from this location,
So Robin, let me have you put this on with your back to the jury. They can't hear you.
so from this location, which we determined to be about 339.47, and right here is 344.09. Is that correct?
Yes.
So this person appeared to be on the highway. Is that right?
Yes. But that, I don't know the accuracy of that. That could be, the accuracy could cover that whole area of the interstate and Cherry Street. I don't know the accuracy from this report.
Well, I'm just asking you that the dot seemed to be on the highway, correct?
The timestamp does, yes.
See a dot that just appeared right there. The timestamp is 3:44:12. Is that correct?
Yes,
That's 3 seconds
yes,
difference, right?
yes.
So it's impossible for a person to be on the highway to be here and then pop up right there, correct?
I don't know the accuracy of the first one. If
Okay.
it's within 65, 100 meters, I'm not sure of what that accuracy is at that timestamp.
What can you tell
Or
me?
the other one.
Can you tell me the distance between here?
I have no idea.
Well, you're an expert in this field. Can you?
I have no idea what the mileage is between that and that.
Okay. So, is it fair to say, is it about a quarter of a mile?
I have no idea. I have no idea.
Your testimony is you don't know the accuracy of this.
I don't know it on this report. It is in a report.
And this was what you testified to yesterday, correct?
That's just the movement on the times.
And this is what you obtained from the phone, correct?
Yes.
Now, yesterday you testified this Snapchat was created on 2/12/2021 at 12:42:26 p.m. Is that correct?
That snap was created on that device at that time.
But you cannot tell when this picture was taken, am I right?
No, not from that, no.
So it could have been taken 3 or 4 days before,
Yeah.
or 30 days before. And this Snapchat was taken on 2/16/21 at 10:24:50 a.m., correct?
That's when that snap was created on that device.
But the same here, you cannot determine when this picture was taken.
No.
Do you have the rock?
Yes.
Has been introduced.
Yes, it's part of whatever.
Do you know what exhibit is this?
So it's going to be the chat. Whatever
Okay.
chat exhibit was.
Now, you also testified yesterday that there was a iOS message to an individual named LaRock, correct?
Yes.
And is this the text message that you read yesterday?
Yes.
Can you read the first? Write that down.
DIS wax why you said had DEM 7.62 bullets again.
When was that sent?
Yeah, it looks like it was at 1:02:38 p.m. on the 12th of February 2021.
And when did that person respond?
1:02:53 on the same day.
Okay. And what did the person respond to?
I got you some.
And what did the individual respond back?
Bet LMK when I can, KAN get 'em.
And what time stamp is that?
1:03:40 p.m.
And did the person that said that he allegedly have the bullets, did he respond?
No.
Okay. And did the individual do any follow-up?
At 3:48:26 p.m. the same day.
What did he respond?
How far you is?
Okay. And that's at what time again?
3:48:26 p.m.
So from this messages, you do not know if the individual got the 7.62 bullets, correct?
No.
You don't know if they met,
No.
correct? Yeah, can you turn off the projector?
Yes, sir.
Can you turn the video? Now this is the video you state that it was introduced into evidence. It was created on February 12, 2020 at 12. At 1:42:35 p.m. Correct?
I don't have the time in front of me, but
If that's what
I
indicated.
don't remember what it was yesterday.
But if that was in the report, would that be
Yes.
accurate?
Yes.
Okay.
If it says exit Creek.
I guess what I instead would ask is for her to have access to the documents we reviewed.
Sure, yeah. Do you have a pull up? Or the documents? This video here, you said was created on 2/12/21 at 1:42:35 p.m., correct?
Local time, yes.
And
Got that nigga in him.
Now the individual in the back seat, you see him in a black sweatshirt, correct?
Yes,
A black shirt with the red letters, correct?
I do.
And a hat, correct?
Uh-huh.
And do you know what vehicle this individual was in?
If you play a little bit forward, it's got the same stitching as the Fusion.
Bad.
So that, the Fusion, correct?
The Ford Fusion, yes.
And do you, if I play the video,
Got that nigga in a bag. Fuck you talking about? Got that bro? Got that nigga in a bag. Fuck you talking about? Got that bro?
okay. Now, when you watched that video twice, did you see any guns in that vehicle?
Not that I recall.
Okay. Now, can I turn off the projector one more time? Projector on. And this video you said was created on February 12th, 2021 at 5:10:27 p.m., correct?
Local time, yes.
So the two videos are about 3.5 hours apart from each other. Is that fair to say?
Yes.
Okay. Now, in this video, watch it. The individual here, he has on a red hoodie, correct?
Yes,
And he has on a black toboggan, am I right?
seems to be, yes.
And is in this the Ford Fusion, correct?
Yeah, I believe so, with the red stitching.
Okay. And the two individuals in the backs as well, correct?
Yes,
And you don't know who these two individuals are.
I do not know.
So in total, there are 4 people in that car.
Yes.
One more time, y'all. And then one more time, I'll do that. Okay. Now, this was the doorbell ring camera you discussed yesterday, correct?
Yes.
Can you tell who this individual is?
No.
And this individual had on what appeared to be a white jacket, correct?
Yeah, it's black and white. I have no idea what color it is.
And seemed to be a white hat, correct? Correct?
I can't tell from the video.
I think, she's a technical expert, so I think the jury can observe just as well as she can these kind of questions. So I think you could save those questions for argument.
Now, they got into this vehicle, correct?
Yes.
And you can't tell what vehicle that is, right?
No.
Can't tell the color either, correct?
No.
have y'all.
Ms. Mathis, cross-examination.
Yes, Your Honor. Good morning, Ms. Morris.
Hey,
My name is Ashley Mathis, and I represent DeAndre Davis. I just have a few brief questions for you this morning. So, on, I think, cross-examination, you talked a little bit about how there was a re-examination in this case of the
Yes.
phones. So, are you aware of sort of the timeline of the phones in this case between when they were seized and when you ultimately examined them?
yeah, I did the extraction, I think the 23rd of January of this year.
Sure. So, are you aware that the phones were originally seized in February of 2021?
Yes,
And I think the iPhone X Max was unable to be accessed by law enforcement locally. Is that correct?
yeah, I don't know which one it was.
Sure. Are you aware that one of the phones had to be sent to the TBI to be inspected?
Yes.
And they performed some examination of their own.
Okay.
And then
yes.
it ultimately came back to Knoxville Police Department
Yes.
custody. And you would agree that you did not perform the extraction that we're examining contents of until January of this year?
And it's my extraction.
Correct. And what is the process for trying, let me withdraw that and rephrase the question. There is a specific process for how cell phones are to be confiscated, correct?
Yes,
And how they are to be controlled to preserve the contents of them for law enforcement purposes, correct?
Yes.
And you would agree with me that the phones in this case have been accessed by law enforcement on multiple occasions, correct?
yes,
And multiple extractions have been done,
yes,
and not all of that was in your presence, correct?
no,
So you cannot attest to how another law enforcement agency might have operated the phone.
no,
So in this case, you have only your extraction to rely upon, correct?
yes.
But you can't say if anything might have been altered prior to your examination, correct?
It would show in the date and timestamps.
So
The
you-
modified date and timestamps, if anything was, if they opened a video on the phone itself.
Right, but you are not aware of if the phones remained in airplane mode when they were in another law enforcement's
No.
custody, correct?
No.
You're not aware of how they were accessed, correct?
No.
You're not aware if they were powered on and off, correct? Or if they were kept in a Faraday box or bag, correct?
yes.
You don't have any personal knowledge as to
I
that?
have no.
So you only have knowledge as to your examination of the phones, which was conducted this year.
Yes, ma'am.
So we're looking back 2 years, but your examination was this year, correct?
Yes.
Okay. And then we talked a little bit about social media and snaps, and I just want to make sure that I understand sort of what you said. So we can see, for anyone who's not familiar with Snapchat, I'm not sure who all is and who isn't, but you would agree with me that on Snapchat you can record a snap directly on Snapchat, correct?
Yes.
And you can upload that directly onto Snap, correct?
Yes.
Or
Yes.
you can save it in Snapchat, correct?
Yes.
But you can also download it onto your phone from Snapchat.
Yes,
And you can also take a video on your phone and upload it onto Snapchat.
yes,
And each of those actions is going to affect the date and time stamp on those videos, correct?
not the exit, but the create and date time that we were discussing yesterday.
Right, and you noted in your testimony that in some cases, you will only be able to see when an image made it onto Snapchat, right? You can't necessarily see when the image, was originally created.
Yes.
Okay, and let's see, we viewed several items, I think, in the exhibits that referred to different Snapchat messages, correct?
Yes,
Snapchat photos, correct?
Uh-huh.
And also videos.
yes,
Did you obtain any independent returns or subpoenas from Snapchat for comparison purposes?
oh, no,
Are you aware if the state subpoenaed any independent records from Snapchat to verify the date or timestamp of any of those records?
I'm not aware of any.
Okay. The same thing, I think we saw some messages that were referred to as text, but they were really messaging within apps, correct? I think we saw some messages that were in a Text Now app.
Yes,
Are you aware if any independent verification was made with Text Now, any subpoena for records?
not that I know.
You have
of.
not reviewed any,
No.
correct? Okay. And then we talked a little bit also about cache data and thumbnails. You'll have to bear with me because I'm not an expert like you are in that area. So you indicated that these phones have thousands and thousands and thousands of images on them, correct?
Some
I
of
think,
them, yes.
I think you said you'd never viewed a phone without thousands of photos
Yes.
on it. And that's because when we view things on the internet, sometimes things are saving in the background, correct?
Yes,
If I click on a photo, it may save in my thumbnails, correct?
Yes.
Same thing with a video. If I watch a video on like Instagram, it could save in the background of my phone, correct? So it does not require me to actively save the image for it to end up on my phone, correct?
No.
So if I'm viewing a news story and I start clicking on images, those could save in my phone, correct?
Yes.
Same thing with videos on Facebook.
Yes.
I think we viewed quite a few that were, they said FB downloader on the tags.
Yes.
So you would agree, you said that if you're passively scrolling through Facebook, that probably wouldn't save them, but clicking one and reading it most likely would, correct? So really, that's not someone actively saving an image to their phone, it's someone just viewing it,
Yes.
correct? And that could be off of a news stream, correct?
Yeah, I don't know who posted it.
It could be off somebody else's
Yes.
repost, correct?
Yes.
So if a friend posted it and you clicked on their images, it could save to your phone.
Yes.
Okay. Give me just a moment. I don't think I have anything further.
Redirect, Joe. Ms. Robinette.
Oh, yeah.
Thank you, Ms. Morris. Have a good day.
Thank you.
Next witness, General.
Our next witness is Dr. Rollins.
Have Dr. Rollins step in. We have demonstrative aids with Dr. Rollins. Ms. Robinette, I will need the microphone, the lapel microphone back. Oh, okay. I got it. You're good. I got it.
Your Honor, if there's demonstrative evidence that maybe that we want to view that and approach before.
I'm assuming that it's the mannequin.
Mannequin.
It's
It
just
is.
the mannequin. Okay, folks, you know, see.
Isn't that
Why don't we just take a recess right now, and when he gets back, we'll
Take
resume.
advantage of that break
Yeah.
as well, Your Honor. Thank you.
Short recess, folks, 5 minutes. Welcome back, folks. Thanks for that break. We need to have a jury out with Dr. Rollins. Doc, will you please raise your right hand? Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Doctor. I wanted to ask you a couple questions about some photographs so I can determine what is admissible in this. So, General, would you like to present to him the ones you wish to use?
Please, Your Honor, can I use your projector, please?
I guess you've spoken to the family
Yes.
about this, and they're okay.
This would be exhibits 433 through 445. 433 through 445. Sir, if I can approach and show you exhibit. Give us your name
Maxwell Rollins.
and where you're employed,
I'm employed at the Knox County Medical Examiner's Office.
and what is your position there?
I'm an assistant medical examiner.
And during the course of your employment, did you perform the autopsy on Mr. Stanley Freeman Jr.?
I did.
And in the course of that autopsy, did you take or have taken several photographs?
Yes.
And what's the purpose of having these photographs taken?
The purpose of the photographs is for documentation purposes.
And these photographs, will they assist you in the presentation of your testimony to this jury?
Yes, they will.
I can show you exhibits 433 through 445, and I asked to look at them collectively, and then we'll go through them individually. All right, you guys good? Looking at those photos, are these photographs from Mr. Freeman's autopsy?
Yes.
And these photos fairly accurately document the autopsy of Mr. Freeman
Yes.
and the items recovered.
Yes.
So for the record, exhibits 445 and 444 and 445, these are the items recovered from Mr. Freeman.
Correct.
I take it there's no objection to those, right?
No, you're not pulling in those. But I do want to talk about exhibits 433 through 443. That these photographs fairly accurately show the location of the injuries to Mr. Freeman.
Yes, they do.
And does it show the relationship of the injuries to each other?
Yes, they do.
Would these photographs assist you in presenting your findings to the jury?
Yes.
We would like to, for purposes of this hearing, just move those photos into evidence so I can show them to you.
For purposes of this hearing, there are 433, 445. All right, folks, we are going to display some photographs that may be disturbing to you. The family has a right to be here if you'd like to be, but it's also certainly acceptable if you need to excuse yourself during the course of this testimony.
433, what are we looking at? What are we looking at?
This is a photo of Mr. Freeman, and there's an injury to the left chest there, which is an exit wound.
Which is what?
An exit wound.
An exit wound?
And the redacted blue box, General, I take it that is some medical procedure that has left a wound there.
Yes, sir. Now, can you tell us what was underneath that exit wound?
The region within the blue box was, if I recall correctly, I believe it was sutured. It may have not been sutured, but what it was, as the judge said, it was medical intervention. When they did a procedure called thoracotomy, which is they incise that part of the chest and open it up to access the organs, and that's medical intervention.
434.
That is a photo of the exit wound on the left chest, labeled as number 1.
435.
That is a closer up of the same exit wound on the left chest.
And in exhibit 435, how can you tell that this is an exit wound?
The characteristics of the defect.
436.
That is a picture in the left armpit region of an abrasion that was actually caused by medical intervention. When the prior picture was shown with the blue box, to do that procedure, they use a device called rib spreaders, and a lot of times the rib spreader device will leave marks on the skin, often near the armpit area, and so that right there would be iatrogenic therapeutic effect.
And so in 436 and 437, we don't necessarily need 437.
That wasn't caused by a wound, that was from medical intervention.
That is correct.
438, yeah, this is, in this blue box, is this covering up medical?
Correct. Correct. That blue box indicates where a chest tube was placed.
This is 439.
This photo depicts the back of the decedent, and in this photograph you can actually see 3 defects. In the left aspect of the upper back, there is an entrance wound. On the mid aspect of the midline of the back is an entrance wound, and then on the left aspect of the mid back is an abrasion consistent with a graze wound.
It's 439. And 440.
And these are the same 3 defects labeled as 2, 3, and 4.
441.
That is a close-up of an entrance wound.
442.
That is a close-up photograph of an entrance wound.
443.
And that is a close-up of the abrasion consistent with the graze wound.
What was that one?
That's the close-up photograph of the defect consistent with a graze wound.
And so, Your Honor, we would seek to introduce all except for 436, 437, and 438.
All right, Ms. Mathis, or Mr. Isaacs.
I mean, I would not have a Banks Harper motion, but they did seem somewhat cumulative with one where he's lying there with the arm extended.
That's 438.
That's out.
I think we're taking that one out. Mr. Robinette.
Can you go back to 439? There was one with a.
I think that's 439.
So that one is out, is that correct?
No, not yet.
Okay, well, I would object to that because I feel like it's more cumulative. The next one would effectively can show the.
So the thinking was here is that I was asking this is how the body was, and then after observing these 3 injuries, they were labeled.
I believe the label was sufficient to show where it is.
Well, I mean, I can tell that that's his head up here, but you get less of the torso there, so I'm okay with it. So I'll note your objection for the record.
And no, back to, I think it's the one that, okay, so
Yeah,
that's what I was.
that's
okay
out.
with that one.
So give me a chance, I'm gonna take that one.
All right. For the record, the court believes the state concedes that 436, 437, and 438 should be removed. And I agree with that. I think all the others are okay. They're not gruesome in nature compared to what we're used to seeing on autopsy photographs. They do not depict medical intervention, and Dr. Rollins has indicated that they can be helpful to him in explaining how these wounds occurred and the trajectories. And so I think all the others are okay if you just strike those 3, General.
Yes, sir.
You good?
Yes, can I make them for ID?
For ID, we'll just leave them 436, 437, 438. So there'll be a hole in the exhibits, but I'm going to explain that to the jury because there's probably a lot of holes in our numbers. All right, Julie, ready?
Yes, sir.
Ready, Mr. Isaac?
Yes.
Ready, Mr. Robinette?
Yes, Your Honor.
All right, bring him on in. I'll swear you in again.
What is this? Okay, I mean, you're going to use it as your photo. I mean, should it be in evidence or just?
All right, everyone may be seated. Stay by the call, jury.
Stay away, John.
Defense by the commissioner.
Yes.
Ms. Robinette. Welcome back, folks. Thanks for that break. Our next witness is already on the witness stand. Doc, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony I'm about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thanks, sir. Do you know whenever you're ready?
Please give us your name.
My name is Max Rollins.
Your name. Where are you employed?
I'm employed at the Knox County Medical Examiner's Office.
What is the Knox County Medical Examiner's Office?
The Knox County Medical Examiner's Office is a building that performs autopsies and figures out why people die.
What is an autopsy?
An autopsy is basically a specialized surgical procedure. It starts with examining the decedent, the deceased individual on the external surface of the body, looking at external parameters like hair length, hair color, eye color. We determine their height and weight. We look at all external features, injuries, as in this case, gunshot wounds. And then after we look at the external part of the body, we move to the internal part of the body and we look at all the organs, starting with the brain and then the heart, lungs, everything internally, and we do the same thing. On the inside, we're looking for evidence of injuries and also evidence of what we call natural disease. For example, is there blockages in the heart? Is there evidence of alcohol use in the liver? Things like that. And so when we take that all together, the external and internal part, that's called the autopsy.
And did you perform an autopsy in this case of Mr. Freeman?
I did.
Now, prior to performing this autopsy, had you performed autopsies in the past?
I did.
Many or few?
Many.
Tell us about your educational background that allows you to hold this position.
The educational background is extensive, starting with undergraduate. I went to the University of Iowa, in Iowa City, Iowa, and received an undergraduate degree and in Russian language. After that, I spent 4 years in Chicago and got a medical degree. And after that, I spent 5 years in Atlanta, where I received my training in what's called anatomic and clinical pathology, and that was my residency at Emory University in Atlanta. And then after that, I spent a year in Memphis, Tennessee, where I did another year of subspecialized training in a field called forensic pathology. And then after that training, I moved to Knoxville, Tennessee, and it was at July of 2020, and I began employment at the Knox County Regional Forensic Center in July of 2020 as an assistant medical examiner.
What is anatomic pathology?
Anatomic pathology deals with looking at disease processes that occur in the body under a microscope. For example, if you've ever had a loved one that gets a colonoscopy and gets a biopsy taken, they look under the microscope to see if that biopsy is benign or malignant. If anybody has ever had a breast biopsy, that's another example. You look to see if there's breast cancer, benign, or if there's another disease process going on. That's anatomic pathology. It's looking at seeing what's going on with the body underneath a microscope.
What is clinical pathology?
Clinical pathology is relatively similar to anatomic pathology, but think of it as a little differently. Instead of looking at the tissue, you're looking more at the liquid part of the body, and what I mean by that is the blood. When you go get your blood drawn and you get, for example, what's called a complete blood count, a CBC, that's actually ran on machines in a lab, in a hospital. And that machine and the personnel and the workers that run that machine in the laboratory, the medical laboratory is what it's known as, they're overseen, believe it or not, by pathologists as well. And those pathologists run that medical side of the laboratory, and that's all known as clinical pathology. Another example would be if you've ever had a genetic test done, that would also be done under that realm of pathology, clinical pathology.
What is forensic pathology?
Forensic pathology is a subspecialty within anatomic pathology. I'm not necessarily looking at biopsies of polyps and breast tissue, what I'm doing is looking at the entire body and looking at organs to figure out why individuals died. We not only look at natural deaths, but we look at what we call sudden deaths, which are typically suicides, violent deaths as homicides, and other unexpected deaths.
What does it mean to be board certified?
What it means to be board certified is during certain steps in the training, there is accrediting bodies. For example, in our field, it's the American Board of Pathology. They administer exams, which are really long. They're usually about 1 to 2 days in length. And when you pass that exam, it indicates that you've got what we would call fund of knowledge, that you've got a certain knowledge base to perform your certain tasks. So I'm board certified in what's called anatomic pathology, and I'm also board certified in forensic pathology.
This time we would offer Dr. Rollins as an expert in anatomic pathology and forensic pathology.
Any objections?
None.
Any other?
Very well, folks, the court will recognize Dr. Rollins as an expert in anatomic and forensic pathology. Once again, that allows him to render his opinion within his area of expertise. Again, just because he renders his opinion, it doesn't mean that you are bound to accept it, but it is your job to judge and wait incredibly to be given to his opinion. So, gentlemen, may continue.
Thank you, Your Honor. Sir, you prepared the autopsy on Stanley Antonio Griffin Jr.
That is correct.
You could walk us through the autopsy that you did on Mr. Griffin.
As far as would you like me to list individual diagnoses at this time, or just
I
a?
apologize. Just what did you do when you received his body, and then I think you took photographs,
Correct.
and we've got copies of those photographs here today.
Correct.
And will those photographs assist you in explaining to the jury your findings?
Correct.
If you could, before we get to the photographs, just explain to the jury how you received the body in and what you do before you start the autopsy.
So the loose procedure for when an autopsy is performed at the forensic center is we receive the body, usually from either a hospital or what we call a scene. If someone dies at home or in an outside environment, whether it's home or in a parking lot or at a hotel, we at our office have a coordinated team. We have investigators and forensic technicians, and we have the pathologists. The investigators will go up to the scene and get all the information and take photographs at the scene. And then the body is transported to the forensic center. And then after it's transported to the forensic center, we get the information and the circumstances regarding the death. And then typically the next day, the autopsy is performed. And that's performed in the autopsy suite with the help of what are called forensic technicians. The forensic technicians help prepare the body. They do, I would say, 99% of the photograph taking. They help take the organs out. They help us as the doctors weigh the organs, and that helps us complete the autopsy. And so that's what occurred in this case, that sequence of events. Mr. Freeman's body came in. The body was in a sealed bag, and on the day of the autopsy, we unsealed that bag. We opened it up and proceeded to take pictures of the external surface of the body, all of the injuries. And then after I was done looking at the external surface of the body and looking at his injuries, we then proceeded to go into the inside and look at the injuries there. And that's the process with that.
And these photographs are from show. Exhibit 433. What are we looking at here?
This is a photograph depicting the decedent and an overall state of the front aspect of him. There's a blue box. Underneath that is medical therapy that was done at the hospital. And there's if you can see on the left chest, there's a red circle, and that indicates a defect from one of the gunshot wounds.
You said this blue box represents what now?
That blue box was from medical therapy done in the hospital, and specifically what would happen there is they actually made an incision on that left chest to enter his chest cavity to attempt a maneuver called a cardiac massage in hopes of revitalizing him and resuscitating him.
So you said the injury above the chest, is that an entrance wound or an exit?
That is an exit wound.
Exhibit 434.
This photograph depicts the exit wound on the left chest, and this is a close-up with a label depicted as number 1.
435, can you explain to the jury how you're able to determine that's an exit?
The morphology of the wound is how we, as doctors, determine the entrance and exit wound. This wound here is narrow, ovoid, and lacks what we call a prominent abrasion margin, and that characteristic of abrasion margin, which is just a little, basically think of a scrape around on the skin, and that's what indicates a typical entrance. This wound does not have that, and the edges of the wound reproximate very easily, and that's how I interpret this to be an exit wound.
This is 439. What we're looking at in the exhibit 439.
This photograph here depicts several things. This is the posterior, or the back side of the decedent, and there's three things that are predominantly depicted here. There are three defects. The topmost defect is an entrance wound. The defect at the bottom in the middle of the back is an entrance wound. And then the defect, if you're looking at that picture up there, yeah, right there, that is a defect as well, but it's an abrasion consistent with a graze wound, as a bullet abrades the skin. It doesn't actually enter the body, but just skips across the skin, and that's called a graze wound.
Exhibit 440.
These are the same three defects with labels. The labels are helpful in autopsy for us to keep the defects separate. Number 2, that is an entrance wound there on the left aspect of the upper back. Number 3 is an entrance wound in the midline of the back. And then number 4 is the graze wound. This is a close-up of the entrance wound in the left aspect of the upper back. And I'm sorry, go ahead.
No, I was going to ask you to explain to the jury how you can tell this is an entrance.
The way, again, we can tell an exit versus an entrance is we're looking at the morphology of the defect, and morphology, again, is just a fancy word of the characteristics of the defect on the skin. This here has a very prominent pink abrasion margin. There's a central defect, and around it is that pink area, and that's what we call an abrasion. And it's very well defined, and that's how I was able to interpret this as being the entrance wound.
442.
This here, there's two things that help me determine that this was an entrance wound. It's not your typical entrance wound with a well-defined abrasion margin. However, when I trace the pathway, the injury pathway is a very short pathway, and there's a fragment of gray metal, which is a fragment of actually fragmented bullet. It was approximately, I think, around 2 inches, and it was just in the subcutaneous muscle. And it doesn't have the classic abrasion margin. It's probably because the bullet was breaking apart. It wasn't striking the skin head on, and so it's tumbling in the air. And that's why the morphology is a little bit atypical. But that's how I was determined that number 3 was an entrance wound. And then number 4, this is a close-up of the graze wound. And the way we can tell that this is an abrasion from a bullet rather than falling on the ground is there's something around the edges of this injury known as skin tags, and that's very characteristic of a gunshot wound. So this is compatible with a graze wound. This picture here depicts an envelope, and on the top of the envelope is a written bullet fragment from mid-back with fabric. This is what we recovered from autopsy from the defect labeled as, I believe it was labeled number 2 in the photographs, and that was the short injury pathway. And from the skin, the muscle underlying the skin, this piece of gray metal fragment was recovered.
Go back and make sure.
It's the next one. I'm sorry, yep, number 3. It was recovered, and it was associated with this entrance defect.
And so that was going to be the one in the mid-back?
Correct.
And so that's where you recovered the bullet fragment from?
Correct. I recovered it approximately about 2 inches above the defect. So you'd be right around the top of the label number 3.
And then 445.
This photograph depicts what we call personal effects, which are belongings that are either on a decedent when they come to the office. They may be in the decedent's pocket, or they may be in like a handbag or a backpack or something like that that comes into our office. And we inventory and label all personal belongings.
So for the record, we'd like to leave those number 6 in as evidence.
Based upon the court's previous ruling, that's for 43 through 445. Folks, there's a couple that we pulled out of there, so there'll be 3 numbers that you won't have. Don't speculate as to why, just not relevant.
Got DNA cards, nail clippings, and Isaac and Mr. Robinette. I've got DNA card, nail clippings, and let me show you exhibit 447. This can be the autopsy. This is 447. So when you perform autopsies, do you take DNA cards?
Correct. We typically take at least one DNA card on every decedent. Correct.
And why is that?
It's just to have evidence. It's one of the standard procedures that we do for evidentiary purposes.
And do you recognize exhibit 447?
I do.
What is exhibit 447?
This is the DNA card that was collected at the time of autopsy on Mr. Freeman.
I can exhibit 447 in his evidence.
Interjection.
None.
447.
You also take nail clippings?
Correct. We take nail clippings on all homicides.
And why is that?
The nail clippings can be sometimes used for evidentiary purposes. If there's a homicide and there was a struggle, sometimes DNA can get underneath the nails, and so we can send those off to a lab and they can determine whose DNA is there.
Show you exhibit 448. You recognize exhibit 448?
I do.
What is exhibit 448?
It's the nail clippings from Mr. Freeman's right hand.
I can have exhibit 448 in his evidence.
Interjection.
None.
Exhibit 449?
These are the nail clippings from Mr. Freeman's left hand.
We have exhibit 449 in his evidence. What about exhibit 450?
This is the bullet fragment that was recovered from the mid-back.
And exhibit 450 in his evidence.
Any objection?
None.
Be 450 and 448 and 449 enter as well.
Now, you prepared a autopsy report as to your findings.
Correct.
And if you could, can you tell us what was your provisional anatomic diagnosis?
Which page are you referring to? I'm sorry.
Front page.
The front page. Can you repeat that question as far as what you'd like me to?
Provisional anatomic diagnosis.
Are you referring to the provisional autopsy report or the final?
I don't have that in front of me. Let's see where you're at.
So did you perform a provisional autopsy report?
We occasionally will issue what's called a preliminary autopsy report. That is correct.
And also a final autopsy report?
And a final. That is correct.
You want to look to see if you recognize this collective report?
Correct. I do recognize the collective report, the PAD, the provisional, and the final collectively. I do recognize that.
And so if you could, I guess, tell us what your findings were.
Correct. So the findings that I found on Mr. Freeman at the time of autopsy, the first finding was a gunshot wound of the back, a perforating gunshot wound with the entrance on the left aspect of the upper back. Would you like me to go into details in regards to all the injuries? The injuries with this gunshot wound, this was the lethal gunshot wound. It injured the soft tissue and muscle of the back. It went through and struck the posterior part of the rib cage at the level of the left fourth posterior intercostal space, and then it struck the left lung, the upper lobe of the left lung, that exited the left lung and struck the top part of the heart, specifically on the left side, known as the left atrium. And then after that, the bullet coursed through and struck the anterior part of the rib cage at the level of the left second anterior intercostal space. And then after that, the bullet exited the body. This bullet was associated with bleeding into the space around the left lung, and at autopsy, we measured approximately 250 milliliters of blood in the space surrounding the left lung, and that's the blood in the left pleural space. Again, the exit with this gunshot wound was on the left anterior chest. The second gunshot wound was a penetrating gunshot wound of the back. The entrance was at the midline of the mid-back, and the injuries with that pathway was just the skin and the soft tissue and the muscle of the back, and that I had already discussed was a very short wound pathway, and the bullet basically just went very slightly upward, and we recovered that gray metal fragment that we had shown in the photographs earlier, and that bullet did not exit. And then the last injury that we identified in regards to the gunshot wounds was the abrasion of the left aspect of the mid-back that we had showed a photograph of, and that was consistent with a graze wound.
Showing you Exhibit 446, is this a fair and accurate copy of your provisional autopsy report and your final autopsy?
Yes, it is.
I'd like to make this introduce this as evidence, Exhibit 446.
Any objection?
None.
446.
You also collect bodily fluids to test whether or not there were any drugs in Mr. Freeman's system.
Correct.
And why do you do that?
We do that as standard policy on almost all autopsies.
Mr. Freeman have any narcotics in the system?
Of the tested substances, there was nothing identified in his system.
Now, would that include like marijuana?
Correct.
So no evidence of any drug use in the system.
No evidence of drug use whatsoever.
Now, using this mannequin, would you be able to show us on this mannequin the direction and location of the injuries to Mr. Freeman?
Yes.
Your Honor, is it okay for me to step
Yes,
down?
Doctor, would you please wear this lapel microphone?
That's upside down. There we go.
It's on and I've got it turned up. Maybe just get it up a little higher, maybe. I'm sorry. It's not the most sensitive microphone.
So the first gunshot wound, the lethal gunshot wound, entered the left aspect, the upper back. And then exited on the left anterior chest. And then the second gunshot wound, which was a very short wound pathway, entered the midline of the mid-back. And it went up very, very briefly. And that was the wound pathway that we recovered a small fragment of bullet. And then the abrasion, the graze wound, was on the left aspect here of the upper back.
So, sir, based. You also had a chance to review the photographs of Mr. Freeman's vehicle?
Briefly, I did.
So what I was going to ask you is that recognizing that there was a hole in the driver's seat, would the injury to his back, to the upper back, be consistent with him being sitting up in his driver's seat?
It could be consistent with that, correct?
And then the injury to the lower back, would that be consistent with him leaning over?
Correct. That would be consistent with that positioning.
Did you also have occasion to watch the video of the crash scene?
I did have an opportunity.
And did you see his arm moving?
I did. I witnessed the movement of that arm.
So these injuries that Mr. Freeman suffered, would they be fatal immediately?
In this case, they were not fatal immediately.
How long did he survive?
Several seconds, I believe, on the order of a few minutes after the gunshot wound.
After being struck by the gunshot wound, would he still have the ability to drive his vehicle?
Absolutely.
Can you tell us the age of Mr. Freeman?
16.
Cross-examination. Mr. Isaacs?
Good morning,
Good morning.
Dr. Rollins. My name is Gregory Isaacs, and I represent the Andre Davis. You performed, and you are an assistant medical examiner, correct?
That is correct.
And I think Dr. Darinka Malusnik is the ME for Knox County, correct?
That is correct. She's the chief medical examiner. That is correct.
And you performed an autopsy on February 13, 2022, correct?
That is correct.
And as typical in terms of your standard practices and procedures, you compiled 2 reports, correct? A provisional autopsy report and a final autopsy report, correct?
That is correct.
And in both the provisional autopsy report and the final, they contained a narrative summary of circumstances surrounding death, correct?
Yes, that is correct.
And explain to the jury what a narrative summary of circumstances surrounding death represents.
The narrative surrounding the circumstances is information that we as a medical examiner receive from our investigators, and that helps put the story together.
Right, and it helps put the story together because your role is to do an anatomical analysis in terms of opining about the cause of death, post-mortem interval, correct?
That is correct.
And you have investigators at the Knox County Medical Examiner's Office, correct?
That is correct.
And they investigate and they interact with law enforcement, correct?
That is correct.
And you would agree with me that's important as to how you form your opinions, correct?
It can be helpful. We use that as one of the ways to form an opinion, correct?
And in this case, if I could direct you to the provisional autopsy report, and I think they were entered as a collective, correct? 444. On page, can you refer to the...
I actually don't have that in front of me. Can I get a copy of that?
The exhibit, please.
The PA. Thank you.
And unlike the final autopsy report, the provisional autopsy report is not numbered, but if you could turn to what appears to be page 4, and the heading is Narrative Summary of Circumstances Surrounding Death. Tell me when you find that, Dr. Rollins.
I'm sorry, page 4, you said?
I'm counting. There are no page numbers on the bottom of the provisional report, unlike the final. But there's a heading that says Narrative Summary of Circumstances Surrounding Death.
Correct. Now, I don't actually know what you're referring to. The provisional report, my provisional report is just the first 2 pages. What's stapled behind that is in addition. That's the MDI, the Death Investigator Summary, that was also sent out as part of this entire packet. This entire packet has my PAD, the provisional, the MDI narrative, and then after that, it has the final, and then I believe, let me look here, I believe at the end of the final is attached the toxicology. So this entire packet is not the provisional, just the first 2 pages.
Okay. Well, let's turn to page 4, the narrative summary of circumstances surrounding death that is attached to your provisional report. Are you there?
I'm there, yeah.
And it's true, is it not, that there was a summary obtained by RFC investigator Erickson from Nurse Sutton and Sergeant Rodney Patton from the Knoxville Police Department, correct?
That's what it appears to be here.
And who is RFC investigator Erickson?
She's an investigator that no longer works at the Regional Forensic Center, but she was one of our medical legal death investigators at that time.
Right, and this narrative summary of circumstances surrounding death also appears in your final autopsy report, correct? It's incorporated.
I believe so.
And let's look at this, and in the provisional report or the investigative report that's attached, it indicates that the decedent was outside with a group of people near the 2800 block of Tarleton Avenue, Knoxville, Tennessee, when witnesses stated multiple gunshots were fired. Do you see that?
Let me refer back to that. Yes, I do see that.
And it says that after multiple gunshots were fired, the decedent reportedly got into his 2003 Honda and fled the scene. You see that?
Yes, I do see that.
And further down on the narrative, you see the third paragraph where it says Sergeant Patton stated no suspect or weapon were located, but multiple casings were found at the shooting incident's location. The casings were noted to be a 40 caliber 9mm and either a 223 or 5.56 caliber. Additionally, another shooting had occurred at the same location on 2/7/2021, and it was possible some of those cartridges belonged to that prior incident. You're aware of that, correct?
I'm loosely aware of that.
Well,
I don't recall that definitively, so I'm loosely aware of that.
Okay. Let's turn to your final autopsy report that was dated some weeks later, and I believe it was 4/29/2021, correct?
That is correct.
And so at this point, there had been additional forensic medical testing, correct? Toxicology?
Correct. The toxicology report was, I believe, completed by this time. Correct.
Additional investigation, correct?
Possibly.
Yeah.
Yeah.
And if we turn to the front page of your final autopsy report, the narrative has remained constant in that Stanley Freeman was reportedly with a group of people on a street when multiple gunshots were fired on 2/12/2021 at around 15:41. It's consistent, but now there's more detail, correct?
Correct.
In fact, it's got a specific time, correct?
I don't know what you're referring to.
Well, around 15:41, I take it that that's military time?
Oh, that's correct.
And it says that reportedly he left the scene in a vehicle and was eventually involved in a motor accident and being partially ejected. So based on additional investigation, your final autopsy report indicated that Mr. Freeman was shot at the scene, not driving away in his car, correct?
That's not correct. You're making inference there. It says reportedly he left the scene in a vehicle and was eventually involved in a motor vehicle accident. That doesn't mean that more gunshots could have occurred when he was in that car. I'm not saying that he was shot at the scene or in the vehicle. I'm saying that, I'm stating here that he was on the street, multiple gunshots rang out, he got into a car. I don't have any indication in my report whether more gunshots rang out after that, but all I know is he got in a car and then he was driving, and then the car, I remember it rolled over.
Right.
And, but yeah, I'm not indicating that he was shot at the scene. There's no indication of that.
But both versions in the provisional and the final say there were shots at the scene before Mr. Freeman got in his car, correct?
That is correct. Yeah, that is correct.
And you can't tell whether the injuries were sustained before he got in the car or after he got in the car, correct? Or let me be more precise, you do not have an opinion to a reasonable degree of forensic pathological certainty that the gunshots happened inside the vehicle or outside the vehicle, correct?
Well, so yes and no, and here's what I mean by that. The first gunshot wound, based on the morphology, it's a through and through. The back goes in the back and then exits the left chest. That could have been sustained either in or outside of a vehicle. The second gunshot wound is supportive of occurring in a vehicle or with something what we call an intermediary target. In this instance, it was probably the vehicle. If he was out on the street, if there's an intermediary target, what I'm trying to say is that the second gunshot wound, the bullet had to have gone through something, because what I recovered was a split bullet. It was just a fragment of lead. So that indicates before it hit his body that that bullet went through something else. Now, if he was outside, I don't know, it may have gone through something else. You're right, it could have gone, I don't know what that would have been, but based on the circumstances that we have here, it is consistent with having gone through like a door or a window or some sort of aspect of a vehicle. So on the second gunshot wound, it is consistent of being fired through a vehicle or some sort of secondary object that it hit and then struck him.
So you would agree with me, based on the narrative in the provisional autopsy report and the report basically 5 weeks later, May 29th, the KPD had no idea what happened, correct?
I can't attest to that. I don't give an opinion as to those circumstances. I've got what I've got here in my findings, so I can't answer that.
All right, and can you please refer to your final anatomic diagnoses, and that is in the final that is paginated, page 2 of 7.
Yes.
And there are a lot of details as it relates to the two projectiles that entered the body, correct, in terms of measurements, where it happened, organs that were pierced, correct?
That is correct.
But there is also some uncertainty regarding when and how it happened. Would you agree with me that based on your final anatomic diagnoses, in addition to the investigative component of the reports, that the gunshots were shot from an indeterminate distance range of fire? The first one, correct?
That is correct. My range of fire is indeterminate/distant range of fire. That is correct.
Could have been a foot, could have been 50 feet, correct?
Most likely not a foot, but I guess it technically could have been if it was shot through a vehicle. That is correct, but yeah.
And that's for the first bullet that entered the posterior aspect of the fifth rib and fractured the anterior aspect of the left second rib. The second bullet, likewise, you indicated in your final anatomic diagnoses that there was an indeterminate distant range of fire.
That is correct. For that gunshot one, correct.
So, based on both the provisional report, Dr. Rollins, and the final autopsy report, we don't know at what location the shots were fired and struck Mr. Freeman, correct? And when I say location, I'm talking about an area, like what address, etc. We don't know, correct?
That is correct. But based on the information we've got, like I was referring to that second gunshot wound, it is consistent through, going through a vehicle.
And you don't know how far the individual was that pulled the trigger when the projectile was launched, correct? You don't know the distance.
I don't know the distance, that is correct. Based on my analysis of the wound on the skin, I can't give a distance in our forensic pathology categories. I can't do that.
And the only thing that we know for certain is the size of the entrance, and in one situation, the exit wound, correct?
Can you repeat that question?
The only thing that we know for certain is the size of the entrance wound, and in one projectile, the size of the exit wound, correct? We know that with specificity.
That is correct.
We know the size of the graze wound to the left shoulder, correct?
That is correct.
And that basically is the universe of knowledge that we have as it related to those projectiles, correct?
I don't understand the question.
That's all you can tell us to a reasonable degree of forensic pathological certainty. You can't tell us how far away Mr. Freeman was when the gun was fired, correct?
That is correct. I can't say that.
And actually, both projectiles went in with an upward deviation, correct?
The second gunshot wound was going more upward than the first, but yeah, both were going slightly upward. That is correct.
Right, I think you said slightly upward. The first one had a slight upward deviation and it tracked from right to left, correct?
That is correct.
Nothing further, Dr. Rollins.
Ms. Robinette,
I like the,
redirect.
Ms. Brooke, Ms. Brooke, pay attention to the screen, showing you exhibit 120, exhibit 120.
Objection unless Dr. Rollins relied upon this in forming the opinions that are expressed in his report. He was not offered as an expert in investigation of this case. He was offered as a forensic pathologist.
I'll be glad to sustain your objection if you're willing to redact and have the jury disregard all the questions you asked about his investigation that he did. I mean, you spent most of your cross-examination asking exactly this kind of stuff. So I understand your point, and I'll sustain it, but I also would have to strike all the questions you asked about the investigation.
Well, then, with all the utmost respect, I will withdraw that objection.
Very good. You may continue, gentlemen.
Showing you exhibit 120, are you familiar with this vehicle?
I am.
And what do you recognize this vehicle to be?
I believe this is the vehicle that Mr. Freeman is driving.
Now, if you could explain to the jury, your role in this case, was your role out here trying to investigate where Mr. Freeman was when he was shot?
That was not my role.
What is your role in this case?
My role as the forensic pathologist is to give the cause and the manner of death and then document the injuries on the body. In this case, with the gunshot wounds, I attempted to figure out the range of fire, and again, as we've discussed, that it was indeterminate. And then I was also looking for other injuries as far as the abrasion goes, the graze wound of the back.
So your role is not to be here to tell the jury whether or not Mr. Freeman was inside the car, outside the car when he was shot.
That is correct. That is the role of law enforcement and my investigators. That's not my role.
And so showing you exhibit 121, again, you recognize this as Mr. Freeman's vehicle.
I do.
Exhibit 122. Exhibit 123. Do you see that bullet there?
I do.
Could this bullet have been one of the bullets, could that bullet have caused that hole in the top of Mr. Freeman's back?
Potentially, yes.
Why do you say that?
It's a fully jacketed bullet, and that it would be consistent with the injuries I identified at autopsies.
And so if this bullet, if the jury has heard testimony that this bullet was recovered from this area of the car, would that be consistent with Mr. Freeman being seated in the driver's seat with his back against the seat, the bullet striking the seat, traveling through his back, and resting in the door jamb?
Check the compound question.
Well, I think she's asking, she's talking about one action that had multiple effects on it. So I get your point, Mr. Isaacs, but I think the question's not compound, just the actions are compound. So you may answer.
Do I need to say that again?
Yes, can you repeat the question?
So, the injury to Mr. Freeman's upper back, the injury that he suffered where the bullet hole entered the back and exited the chest, based upon the photographs here, would that be consistent with Mr. Freeman being seated in the driver's seat? Being seated in the driver's seat. Being seated in the driver's seat with his back against the seat, the bullet entering the back seat, exiting the front seat, entering his back, exiting his chest, and coming to rest in this area here in the door.
It could be consistent with that.
And now, if there is not a hole to the bottom seat, where he suffered the injury wound in the bottom of his back, would it be consistent with Mr. Freeman's body having been turned and one of these mini bullets that entered the passenger side of his vehicle striking his back?
Yes, it could be consistent with that.
And so in order to determine where Mr. Freeman was when he suffered these injuries, do we have to take all of the evidence together?
That is correct.
And as far as the narrative that you received from your investigators or from KPD, that was just a narrative that was received?
That is correct.
You're not here telling us that that narrative is accurate?
That is correct.
And whether the narrative is accurate or not, does that have an impact?
Check the leading, Your Honor.
Sustained.
The veracity of that narrative, does that impact your findings in the autopsy?
And no, it does not.
What impacts your findings of the autopsy?
As far as not necessarily impacts my findings, but my findings would impact the story, and that's the gunshot wounds here that I found, and so that tells what happened to him.
The bullet wounds that Mr. Freeman suffered, does that have, whatever narrative you received, does that have any impact at all about you determining where those bullet wounds entered and exited Mr. Freeman's body?
It does not.
Thank you.
Read a record, Jonathan.
No, Your Honor.
Mr. Robinette.
Oh, yeah.
Thank you, Doc. Have a good afternoon.
Appreciate
If you could just give us the exhibit back there.
Mhm.
All right, further proof from the state.
Here, at this time, the state of Tennessee, please.
Ladies and gentlemen of the jury, the state has now rested its case in chief. That does not necessarily mean that you've heard all the evidence that will be presented to decide this case. The defendants have no burden of proof in this case, but they are given an opportunity to present evidence to witnesses and exhibits. We will do that after lunch if they wish to do so. If they choose not to present any evidence, then we will go into closing arguments. But we're not there yet, so please, once again, do not discuss this case among yourselves. You can leave your notebooks in the chairs and go with the officers for lunch. It's probably be a little bit longer lunch today, probably more about like 1:30 when I see you again. So have a good lunch, folks, and go with Officer Thompson. Evan, you may be seated. All right, do we have a motion from the defense?
Your Honor, at this time, we would make a motion pursuant to Rule 29 of the Rules of Criminal Procedure that the state has not met their burden as to each element of the offenses charged. I do have some case law, if I could present it to the court.
All right.
And here's some copies for you. Your Honor, I'd like to go backwards, if possible, in this case. We're faced with a 3-count indictment against Mr. Davis. The third count alleges aggravated child abuse, so I'd like to start there. Your Honor, the elements of the offense here require that the state prove beyond a reasonable doubt that the defendant knowingly, other than by accidental means, treated a child in a manner as to inflict injury, and that serious bodily injury resulted, or that a deadly weapon was used in the commission of the offense. Your Honor, I believe here that there has been no proof in this case that would satisfy the mens rea element as to this count of the indictment. I passed up State versus Hansen, which for the record is 279 Southwest 3rd, 265, and State versus Ducker, which is 27 Southwest 3rd, 889. Your Honor, in each of these cases, the court addressed the mens rea element required to establish aggravated child abuse. And in each of those cases, the Tennessee Supreme Court has talked about the fact that aggravated child abuse is a nature of conduct offense rather than a result of conduct offense. So here, it's our position that that would require proof that the defendant knowingly treated a child in a manner as to inflict injury. So the knowingly has to apply to the acts and the intent, not to the result of the conduct. So here, I don't believe that there's any proof in the record that would support, even under the theory most favorable to the state, that that was present in this case. There's been no evidence that anyone was aware that Mr. Freeman was in the car, that the defendants were aware that that was the individual that was there. I think we've heard some proof that the state would maybe try to argue that the act was in response to the initial Honda that we had seen on the screen. However, the proof has indicated that that was during school hours, and there's no proof to indicate the defendants would have known a minor was in that car. So even, I believe, under a theory of transferred intent in that aspect, there is not proof that anyone would have had knowledge a minor was in the car or would have had the intent to treat a minor in such a way as to inflict injury. And I don't know if the court had any specific issues it wanted to address on this count before I move forward.
So you're saying the mens rea of knowingly applies to the fact that the victim was under 18?
I think you have to have knowledge.
Know.
You have to have knowledge, and you have to have the intent to treat a child. So if you look at this case law, it specifically talks about how the knowingly modifies treatment of the child, not the result, not what ultimately occurred, but what they were trying to do. And I think each of these cases support that position. And I think that that is going to also dovetail into the second count of the indictment, because the second count of this indictment is pursued as a felony murder in the perpetration of aggravated child abuse. So here, the state would still have to establish an unlawful killing of the victim in perpetration of the aggravated child abuse, but the third requirement is that the defendant intended to commit the underlying offense. So they would require proof here that the defendants intended to commit child abuse, and in the course of that, there was a death. Again, I think that the proof is lacking. I don't think we've heard really or seen any proof about intent as to Mr. Freeman or specifically as to that Honda, or any proof that that would have involved a minor either. And I think I said this before, but the initial video was still during school hours too, which I think also undercuts that theory. Finally, when we're looking to the first count of the indictment, it's charged as first-degree premeditated murder. So the court is aware that that's an unlawful killing. They need a showing that the defendant acted intentionally and that that killing was premeditated. So we know that premeditation requires the exercise of both reflection and judgment. And that also the premeditation has to be formed, even briefly, but it must be formed prior to the act itself. So, I think really the only proof we've seen as close as we can get to what actually happened at the time of the shooting, again, is going back to that video here. So, we see the initial video, we see cars in front of Austin East. The time span, as the court has seen, between when the first car turns onto Tarleton and when the second car follows is a span of maybe 30 seconds between when those cars turn and when a shooting occurs. So it's our position that there's not been any proof introduced directly as to either defendant as to premeditation related to either transferred intent, if the state's theory is that the initial Honda was at issue, or as to Mr. Stanley Freeman specifically. So, and I think that the fact that there was such a brief time between when those cars were together and when the shooting occurred, that there's not the ability to form premeditation in that brief span based on what the state's theory is. So, you know, the court also heard that just as we turn on to Tarleton, the casings are at the very beginning of the street there. That section of the intersection is less than 500 feet. So we're talking about seconds. And again, I think circling back to the age of the defendants at the time is going to be relevant to the formation of premeditation and intent as well. Let's see. Oh, and additionally, I think that in the initial video, if the state's theory is that this initial encounter with the Honda, the unrelated Honda, is a part of the potentially the transferred intent, I think the fact that the blue car turns off of the screen and that the Honda turns around and does not pursue them undercuts this theory. You know, we've heard that there's an altercation, but there's no shooting, there's no speeding off, there's no actual pursuit happening. So I think the fact that there's 8 minutes in between undercuts that argument as well. So I don't believe that there's proof of premeditation. I think that the court has the ability here to, even under the evidence most favorable to the state, dismiss or let the lesser included offense of second-degree murder go to the jury rather than first-degree premeditated murder. And we would ask the court to dismiss counts 2 and 3 of the indictment.
Thank you. Mr. Robinette?
Yes, Your Honor. Ms. Mathis did a great job putting the point together. I just want to add one thing. I don't believe that the act of child abuse is a strict liability kind of issue. It has the element of knowingly in there. It's not similar to the statutory rape of a child. No, where they don't have to prove that where the state doesn't have to prove that the person knew that was a person, a minor. So in this case, I believe the state has to prove that Mr. Jordan, Mr. Davis knew a minor was in that vehicle because of the element knowingly in that matter. And that will also go to the second count, because if there's no aggravated child abuse, then the felony murder will fall, Your Honor. And the first count is the premeditation. Like Ms. Mathis' argument, and there was no evidence of deliberation in there. You know, there's no evidence to show that anybody at the time of the shooting planned anything or got out of the vehicle. There's no proof. And the fact that I don't think the state even made its burden to put Mr. Jordan at the scene of the crime, Your Honor, and you heard testimony from Jeremy Hines. They rely on that testimony. And Mr. Hines said Mr. Jordan was not there that day. So therefore, Your Honor, based on that, I ask that all counts be dismissed against Mr. Jordan in this case.
Thank you. General?
Seeing that the defense started backwards, I'm going to follow the same path. With regards to these cases, I think the suggestion that there was no mens rea with regards to their actions circling around a senior high school ignores the fact that the majority, if not the vast majority of the people that are coming out of that building are minors. So to suggest that the state has not provided any proof that the defendants had the mens rea or knowledge with regards to the occupation of those vehicles being a minor, I think ignores the fact of the context of where this particular event took place. And with regards to the premeditation aspect of this particular case, once again, that has to ignore the fact that we have voluminous records that present these two defendants posing with their weapons before and after. And having been found with numerous rounds of ammunition at their residence and the electronic information indicating the desire to acquire ammunition before, certainly is sufficient to suggest to the jury that these acts were premeditated for the purposes of the first-degree murder. So the state believes that there is more than sufficient information for these 3 counts to go to the jury for their consideration of this particular case.
All right, thank you, sir. So when the court examines a motion under Rule 29 for judgment of acquittal, the court has to look at the evidence in light most favorable to the state and draw any reasonable inferences from that evidence in favor of the state's theory. And if a reasonable juror, after doing so, could not find sufficient evidence to find the defendants guilty, then the court itself would enter a judgment of acquittal on that count and any lesser included offenses that could not be supported from the evidence. So at this point, the court looks at all the evidence we've heard in light in a favorable light to the state. And so I'm going to start from the beginning with count number 1. I certainly believe that the state has met its burden of proof to show sufficient evidence of premeditation. As we've all said many times, premeditation can occur in an instant. I don't think you have to go back and look to when they're arming themselves the day before and going to the school with weapons in their car. I think you can look at what happened when Mr. Freeman unfortunately crossed our paths and they opened fire multiple times into this vehicle, causing the death of Mr. Freeman. That is not a spur-of-the-moment reaction where you just shoot one time and it appears that the bullets are following along a passing car. We have bullets in the front, then the side, and then in the rear as it's going. So this is certainly, I believe, sufficient evidence to show somebody was attempting to kill the driver of that vehicle. We have litigated already on whether or not a juvenile can be guilty of committing child abuse, and I ruled on that in writing, I believe. The statute says a person who treats a child under the age of 18 in such a manner as to cause injury is guilty of that. And a person is anyone, depending upon the statute. Some statute includes a person before birth, but certainly anybody after birth would be considered as a person for purposes of this statute. Therefore, the court found that someone under the age of 18 can also be guilty of child abuse. The argument that the defense are both making in counts 2 and 3 is that the state has failed to show that they knew that the person that they were allegedly abusing by shooting was in fact under the age of 18. It's an interesting question. If you look at a number of the statutes that we have, the intentional and knowing can refer to one element of the offense, but not all of those. So it could be that the knowing requirement is that you're knowingly abusing a child, and you can be reckless as to whether or not they're 18 or younger. I don't know that that's the case here. I'm going to look at it as if every element has to be shown through a knowing mens rea. And so when you look at what does knowingly mean, it means that you're aware that circumstances exist. And so what we have here is we have a number of juveniles in a vehicle around a number of juveniles after school, where a lot of juveniles are leaving the school. And you have Mr. Freeman, who was only 16 at the time. The autopsy pictures certainly look to me like somebody less than 16 years of age, certainly under 18 years of age. And you have entrance wounds into the car as the car appears, the car approaching, where the person would be looking right at the person coming at them. And so I certainly think under Rule 29 there's sufficient evidence to show that whoever did this knew that the person in that car was under the age of 18, even if they were wrong about who they thought they were shooting at. And so I think it's sufficient in counts 2 and 3 to get it to the jury. I'm not saying the jury's going to find that that's true, and certainly the defense has a good argument to the jury, about those, and we'll let them decide, though, if it is proved beyond reasonable doubt. But I think for purpose of Rule 29, it is sufficient, so I'm going to deny the defense motion on that. Has the state filed? I guess not, since they're juveniles, no 609, right?
Yes.
All right, so what I want to do before we break for lunch is have a moment hearing, and what that is, folks, is your lawyers are going to ask you a couple of questions on the record just to know that the decision on whether or not you're going to testify in this case will be completely up to you. So I'm going to swear you in. You're just going to remain seated right there at the table. Your lawyer's going to ask you a few questions. I'm going to start with you, Mr. Davis. You please raise your right hand. Other one. There you go. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Ms. Mathis.
Mr. Davis, I've represented you since summer of last year, is that correct? And I've met with you on a number of occasions to talk to you about your case, correct? And have we reviewed some of that discovery in your case? And we've talked about what we expected to happen in the trial of this case. And we've discussed strategies for our defense, correct? And you've been present throughout this case, correct? You've seen the truth. And we've talked about your right to testify in this case. And we talked about the fact that you have a right not to testify in this case. And I've advised you as to my opinion, but you understand that the decision is yours if you do or do not testify in this case. And have you decided if you would like to testify in this case? Would you like to testify in this case?
And you do know, sir, if you wish to, that you certainly could. You understand that? Okay. And so what's going to happen after lunch, if there's proof, we'll hear that. At the point your lawyer says the defense rests on behalf of Mr. Davis, at that point you can't change your mind, okay? But you can change your mind all the way up until then, all right? Okay. So, Mr. Jordan, would you please raise your right hand? Do you solemnly swear or affirm the answers you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Ms. Robinette?
State your name for the record. Mr. Jordan, I have represented you before June of 2022 in a bond hearing, and I represent you throughout this entire process, and did I provide with all the discovery in your case? And did we meet on numerous occasions to discuss the discovery in your case? Was I able to answer any questions that you have? And did we discuss the trial that we were about to go into? And did I discuss with you the strength and the weaknesses of your case? And did I discuss with you the right to testify? And did I discuss with you the right that you don't have to testify? And based on, and you were here throughout the trial of this case, were you not? And you observed everything that had happened, you know? And during the trial, was I able to answer any questions that you had? And do you understand that you have the right to testify when you tell your side of the story? Yes, sir. And based on the decision that we have discussed, what do you wish to do? I do not wish to testify. Now, did anybody or anyone or me promise you anything in exchange for you to waive your right to testify? No, sir.
Very good. And same thing, Mr. Jordan. You can change your mind all up to the point that your lawyer says the defense rests. You understand that, sir? Yes, sir. Okay. Does the defense, either side, anticipate defense proof after lunch?
Look backward, Your Honor, but I can't have one witness.
Okay. All right, that's fine. I sent you, did you all receive my first draft of the instructions last night?
Yes, Your Honor.
Okay. I haven't really made any significant changes. I did add identity today, that the state has to prove identity, and I added a redaction instruction to tell them don't speculate on any redactions, and that there may be missing exhibit numbers, but don't speculate on that. Is there anything else that y'all saw that you think I need to add that I left out?
Was there a 404B instruction there?
I did, and I thought about it, but I wasn't sure what specifically we were talking about, because I kept out the gang stuff. So what?
I didn't know about the gun possession.
Yeah, y'all want me to do a 404B instruction on the gang? It's 4210 is where it is in the TPI on the gun, because they're juveniles.
I do, Your Honor.
Okay. Okay.
Also, Your Honor, I'm not sure if I missed it, but I didn't see any instruction about circumstantial evidence.
It's there, it's at the very end. It's if it's not on the last page, it's the second to last page.
Yeah, also for the circumstantial evidence, we would
Talk
add,
about the,
I'm sorry,
what, the definition of circumstantial, or you
I'm
talking-
sorry, criminal responsibility.
Yeah, okay.
We would ask for, looks like there's a couple of paragraphs that were not included.
No, I left out.
Well, I mean, we don't always include them.
Yeah.
And so it is, paragraph, to find the defendant criminally responsible for the acts of another, it's not necessary for you to find that the defendant was present or that the defendant took a physical part in the crime. I don't know if it may have been in there, I guess I just,
No, I guess I did. I remember seeing it, and I guess I took it out. Yeah, okay.
and then also, Your Honor, the last paragraph, it is not a defense that the person for whose conduct the defendant is criminally responsible, I would say, has not been prosecuted.
Because you're thinking there may be more than two people in there.
I anticipate that being the argument. And also, I think General Dillon pointed out Dr. Rollins as an expert.
Yeah, I didn't get that. All right. Ms. Mathis, what do you think? Anything else I need to add or not?
Your Honor, is there any, just thinking about the Germany Hines testimony, is there any special way that we need to instruct regarding an unavailable, he's not a missing witness, but he
Yeah.
is I don't know if there is, I should have looked, and I apologize, I didn't, if there's any special treatment we needed to give to that.
That's a good question. The only thing that I know of, and I'll look again at lunch, the only thing that I know of is there's a section where you're looking at credibility witnesses and impeachment and all that. It's usually dealing with impeachment with a prior inconsistent statement. And I'm trying to find it here. What happened is I made those changes last night, folks, and I saved it in my house and the server wasn't working, and so I lost all the things that I sent you. I no longer have. So I'm trying to find it here. So I don't know what page it is for you guys. I don't know what page it is. So did I add identity? I told you that. Oh, here it is. Okay, so there's a paragraph that says a witness may be impeached by proving that he or she has made some material statements out of court which are variance with his or her evidence on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of such prior inconsistent statement may not be considered to you for truth of matter asserted in this statement. So that's why I put that in there for that. I'm not aware of any. There may be something. I'll check that out during lunch, Ms. Mathis, and see. If not, I can try to structure something.
Well, and I should have looked, I've never had that, it's just not in my standards.
Yeah, I think I've had it before, but I just don't remember. I'll look. If I don't find one, maybe I'll structure something and submit it to you all after lunch. Anything else you can think of?
Not right now, Your Honor.
Robin? All right, I'll work on that during lunch. So it's 12:42, so we'll break till 1:30 and hear defense proof. And as far as who wants to go first, I don't care. Y'all can work that out among yourselves, okay? Court stands in recess to 1:30.
Oh, good job.